Welcome back to Good Law, Bad Law. You know, we all know that uneasy feeling when some company or some online vendor asks us for our personal data, our credit card, our social security number. Well, that uneasy feeling is well-founded, as we have been hearing more and more in the news. Massive data breaches in companies like Equifax and Marriott and other big companies, hospitals, retail enterprises. And my guest today is here to help us understand what these data breaches are all about and what consumers are doing about them. My guest is Andrew Friedman. He's a partner in the law firm of Cohen Milstein, and recently a federal judge in Maryland appointed Andrew co-lead counsel in the Marriott data breach class action, a massive, perhaps the most significant data breach case involving literally hundreds of millions of customers who stayed in Starwood Marriott hotels and who had their personal data stolen by criminal hackers. Fascinating explanation from Andrew, something I didn't really fully understand, though I've been reading the stories and worrying about it for a long time, as I'm sure most of you have as well. A fascinating walk through this issue with Andrew Friedman on massive data breaches. Stay tuned and enjoy the episode. On today's episode of Good Law, Bad Law, we're talking about data breaches, massive data breaches, the loss of massive amounts of personal data held by companies due to hacking. And to help us understand this issue, which has been all over the news in so many different situations, is my guest, Andrew Friedman, a partner in the law firm Cohen Milstein from their Washington office. So first of all, Andrew, welcome, and thank you so much for being on the program today.
Thanks for having me.
Andrew, you are just recently appointed by a federal judge in Maryland to be co-lead class counsel. We're going to talk about what that means in one of the largest data breaches to date, that the data breach involving literally hundreds of millions of individuals whose personal data was hacked in the Marriott hotel chain. So we're going to talk about that case in some detail to understand the issue, how this happens and what the significance is and what consumers who've had their private data breached and hacked into can do about it. Tell us a little bit about yourself as we get started, how you got into law, the kind of law you practice, and then we'll work our way into the story of this incredible Marriott case that you're involved with.
Sure, I appreciate that. I graduated law school in 1983 from George Washington University, and I graduated into a pretty bad job market, actually, for lawyers. Maybe not as bad as the one 10 years ago, but it was not a great one. I immediately went to the U.S. Patent and Trademark Office, where I was a trademark attorney, which was a very interesting area, but I wanted to do more. And so after a couple of years, I went out and I looked for a firm, and I found, lo and behold, Cohen Milstein, which was under a different name back then, which was a very small litigation shop that did almost exclusively class actions. And I've been here since 1985, so I think the math comes out to 30, almost 34 years.
We don't have to count. I know the feeling.
It's a long time,
Yes.
And I've gained some gray hairs over the course of it. But I actually, for many years, I did almost exclusively securities litigation, mostly shareholder cases. And the firm specializes in securities and antitrust and civil rights, and eventually started doing consumer work, all on the plaintiff side, or I should say about 99% on the plaintiff side. So at some point, I started doing more and more consumer class actions, and I found them a little more interesting than the securities class actions.
Why do you say that?
I went forward and
what was more interesting about the consumer type cases for you?
Well, the thing that really interests me, and I think most people, is whereas the securities cases are they're very legitimate, and there's always a lot of fraud that we're alleging there. Most of the people you represent are large institutional investors or small-time investors, but they're sort of nameless and faceless. They're not things that you can reach out and touch. It's all about money because people are investing in companies really to make money, whereas the consumer cases really impact just about everybody you know. They could be small widgets, cars, insurance, whatever you have. It's all about a small-time consumer who's not trying to make money. He's trying to buy a product or a service and doesn't expect to be deceived.
Right.
And that really grabbed me a lot more. So I've been doing that probably for the better part of 15 years. I'm sorry, go ahead.
Yeah, and then you got, and then from the consumer type cases that you've been handling, you got into fairly early on, at least early on as far as the public consciousness of the problem, these cases involving breaches of private data. Is that right?
That's correct. And those started to be filed more and more, I'd say, 5 or 6 years ago. And we didn't throw a lot of cases. We just didn't file that many cases. And frankly, we still don't file a lot of data breach cases. They have to be the right ones. But I started to get involved in a few of them, got my feet wet, and then probably my biggest opportunity that came to me was in the form of the Anthem case, which was at that time one of the largest data breach cases, impacting approximately 79 million people who had mostly Blue Cross Blue Shield insurance.
Okay, so now we're talking. So now we're into it. So let's just get this out and explain this clearly. When we say a data breach or a data breach case, what are we talking about exactly?
Generally, that means some third party, a criminal, has breached the security of a company, gone in and taken out personally identifiable information. That usually includes your name, your address, could include financial information, could include social security numbers, health information. What they've done is they've exfiltrated that information. Generally, they've exfiltrated the information. Some of the data breach cases and some of the ones that didn't fare well weren't true exfiltration. They were based on somebody had a laptop and the laptop got lost. So the company then said, hey, your data may be at risk. We don't really know what happened to it, but it wasn't necessarily exfiltrated. It wasn't necessarily, a criminal may have taken a laptop. He may not have been looking for that kind of information. He may just like the laptop. And literally some of the cases involved people breaking into cars and stealing some employee's laptop. So there's sort of a difference there. What I'm really talking about in the cases we get involved in are cases where there is an intentional hack. A criminal goes out of their way, usually a sophisticated criminal goes out of their way to go into a company to breach the security, if there is any, or any real security, and exfiltrate that information.
And why are criminals interested in taking this information? What is it they're looking to do with that information?
Your personally identifiable information can be used hundreds of different ways to create fraudulent identities. Armed with things like social security number or your name and date of birth, your address, they can bring bits of that information and create a new identity or breach into your credit card. So those are some of the obvious ones. People get their credit cards stolen all the time. But if you have that information on a company's server and it's sitting there with your name, thieves can go in there and pull that information and literally create a new credit card identity using your credit card number. So that's an easy one. So you also get things like fraudulent tax returns. People send their returns. They want to get their refunds. They go to get their refunds only to find out somebody's already taken their refund. So that is a perfect example of identity fraud, which negatively impacts you almost immediately.
Now, my wife just got a call a couple of nights ago from somebody at one of the credit card companies for one of the credit cards she has about a fraud alert and some purchases that somebody was trying to make with her credit card in Oklahoma. And we're in Pennsylvania, and we're nowhere near Oklahoma. In fact, never been to Oklahoma. Is that the kind of thing that could come about as a result of a data breach?
Absolutely, absolutely. They're taking your identity, creating a new identity, and sort of, and then charging up your credit card. Generally, in that respect, the credit card companies are going to cover you. Usually, they'll cover you, but you're out of pocket your use of that credit card for time. And if it's debit card, they may not be doing that. Same thing holds true for them. But if they take your debit card, they could rack up charges.
So you mentioned that early on you got involved in the Anthem case. Tell us a little bit about what that case involved.
So Anthem is one of the big insurers that actually is sort of an umbrella organization that owns probably most of the Blue Cross Blue Shield entities, and then some non-Blue Cross Blue Shield entities. And Anthem held all of the data for all of those entities, all of the personally identifiable information of every insured under all these plans in all these states. So it must have been, I'm just speculating, I just don't remember, but it could have been in 40 different states, something between 35 and 40 different states. And hackers, very sophisticated hackers, went into Anthem's major system and they exfiltrated that data. And they pulled out really the mother lode. They got the name, the address, they got health identification numbers, and they got social security numbers. And that put 79 million, approximately 79 people's data at risk. And so there were numbers of cases filed, and it became an MDL. So cases were filed in numerous federal courts around the country, and they were consolidated by the judicial panel in the Northern District of California.
So MDL, just so for people who don't know, including probably a lot of lawyers who don't know what MDL is, that's multi-district litigation, right? So
Correct.
So you might have a lawyer file a case in one federal court, another lawyer files in a different federal court in a different state, and for ease of handling and managing that litigation, they can all be consolidated in one federal court with one federal judge handling all the claims. Is that right?
That's correct.
Mm-hmm.
That's correct.
Okay.
It's obviously to streamline the case, to increase efficiency. You obviously don't want to litigate. A company doesn't want to litigate in 20 different federal courts. So it goes to the panel, and the panel makes the determination, A, whether all those cases should be consolidated, and B, where should that case be sent. And in this case, even though Anthem was based in Indiana, the judicial panel sent them to all the cases to the Northern District of California.
And I know that case settled. It's been reported that Anthem case settled for $115 million.
That's correct.
What we're going to talk mainly about the Marriott case, but this must be in some way a sort of groundbreaking case. Is one of the earliest cases in this area. And I know you probably can't talk about the particulars of the settlement, but what were the claims that led to that settlement? So we know where there's a big data breach, a bunch of hackers get in, steal all this data, lots of people at risk. But what was the actual case against Anthem and that led to that settlement?
The case against Anthem, and actually was against the individual insurance companies as well, because they gave their information to Anthem. There are claims. There is no one federal law. It's not like the securities or their antitrust laws. There's no one federal law that applies to data breach, at least in terms of bringing civil litigation to get money back to the consumer. So what you'd go ahead with are basically state claims. And the core state claims in a lot of these data breaches, but especially Anthem, excuse me, are negligence. At negligence, look, you had a duty to the insured to protect their personal information that they willingly gave to you, and you didn't fulfill that duty. You were negligent in that. Their breach of contract claims. They made assertions and promises in their contracts with each of the insureds about data security. They said, "Hey, we're going to protect your data," and they failed in that contract. They're also consumer statute claims,
like consumer protection.
Mm-hmm. Right, consumer protection in a lot of states. So they're sort of like fraud laws. They say you can't do something that's unlawful, unfair, or deceptive. And we allege that almost in each state, they had done that. We didn't actually litigate all of the claims because the judge did something called the bellwether process, which I can get into if you want, but we don't have to. But those are sort of the essential claims. There are a lot of other claims. There are statutory, notice claims and some state data breach are claims we brought. But essentially what these cases boil down to are contract claims, deceptive practice claims, and negligence. And really that's really, if you could bring this in a state court, that's what you would say all the time. You'd say these companies were negligent, and that's what we always alleged Anthem was.
And
just
so
didn't fulfill their duty.
So you mentioned 79 million people whose data was breached in that Anthem case. In order to have a claim, does each of those 79 million people have to show that something bad happened with their data, or is it more the risk of their data being used in some criminal way that creates the harm?
It's a good question. You sort of have to parse out the settlement versus the arguments that are made. In settlements, no, you don't have to show that. If you are able to show that, in other words, show that your data was breached and you suffered some kind of loss, like the tax fraud we talked about, or somebody took out a loan in your name and you suffered an economic harm, you can get specific money for that within the settlement terms. But we don't require in most of these settlements, and certainly not the Anthem settlement, for people to actually have shown that actually happened. As you said, this increases when somebody takes your data, it increases dramatically the likelihood that you're going to suffer identity fraud or identity theft at some point. Somebody could steal your identity. Also, there are things called benefit of the bargain damages, where we're saying that you paid for your insurance X amount, but you didn't get the full value of that insurance because part of the value of the insurance was, in fact, the data protection. But you didn't get that. You didn't get the full benefit of the bargain. But in the Anthem settlement, what we were able to achieve was not only the out-of-pocket losses that I described, but we really focused on how can we protect the class members going forward. The problem with data breaches is not everybody, as you described, not everybody's harmed at least right away, at least harm that they can see. They are harmed because their data is out there and increases the likelihood that they're going to get breached, but that may not manifest itself for a year, 2 years, 5 years. So what we try to do, and I think we were successful in Anthem, is get some kind of protection for the class members going forward so that they could monitor their credits. So they could monitor if somebody was trying to hack in, trying to create a new identity. So we were able to achieve credit monitoring for a number of years that anybody could get if they're a class member. And that credit monitoring is a minimum of 4 years now. It's triple bureau credit, a credit bureau protection. And it also has insurance. It has a lot of, so it was one of the first cases to get that kind of relief. But also we gave the alternative, and I think we were the first case to do this. We gave the alternative that if people already had credit monitoring and could show that, they could get a cash award instead. So we said, look, we didn't want people to say, wait, I'm one of the few people that really care about this, and I have my credit monitoring in place. Why do I want additional credit monitoring? I still think people could use the extra years because most people don't want to pay that much going forward, but we gave them an alternative. We'll give them cash. So we're able to give each person $50. And other cases subsequent to that have used that model as well. And actually now that number is going up in other cases. So I think we sort of started something that I think is good for the consumer.
Well, and I want to come back to the idea that this did start something in a minute. But just when was that? When was the Anthem case resolved finally?
It was actually settled, I believe, in 2017, but it didn't finally get approved until 2018.
Okay.
And there was some appeals, and those were dismissed. So it finally was approved in 2018.
Okay. I will. Now let's turn to the Equifax case because you were also instrumentally involved in that litigation, and I think for a lot of people, myself included, that's really the first case that I can remember reading about and hearing about big, massive data breach. Now that we've kind of walked through some of the steps involved, just give us a bit of a summary of what that case involved.
Same thing, this is one where the criminals got the mother load, including Social Security numbers. So Equifax is one of the three major credit bureaus. So you don't actually contract with them, at least very few people do. But when you go to get a loan, when you go to swipe your credit card, Equifax is one of the credit bureaus that sends that information right away to tell you or to tell the merchant whether or not you're creditworthy, and or the bank whether you're creditworthy when you take out a loan. So they are central to sort of the financial system here as one of the three credit bureaus. And again, hackers got in. We allege because of very lax security or no security, we're able to take out this mother load, and they had this great data, including Social Security numbers, and names, and addresses, and all the stuff you need to create identity theft. So what made this especially, I guess, pernicious is, again, you don't contract with the credit bureaus. It's all the merchants and the banks that do, and you sort of give them access, but you don't have a relationship with Equifax.
Right.
They're just there. So it's not like you went out. You can't even be accused of saying, well, I didn't even shop for, I could have looked for something better that maybe had better data protection. I could have looked at that. That's not your option. When you're a consumer, when you're borrowing money or using your credit card, that's not your option. This is just sort of thrust on you. So they play this incredibly central role along with the other credit bureaus in our entire financial system, and yet you have no control over it. So it really has a different feel about it. And this one impacted, I think, around 150 million people.
Well, yeah, and that's fascinating, too, because like you said, this is a different situation where the individual consumer doesn't have a contract, perhaps isn't even really fully aware of the fact that Equifax has your personal data, your most vital personal data. So given that, is the theory against Equifax for failing to protect that data the same as what you described earlier in the Anthem case? Is it a negligence case that they had a duty to protect that data, even in the absence of a direct contract with each consumer, and they failed to live up to that duty?
Yeah, I think you said it better than I could have. At base, it really is a negligence claim. That's there is a contract claim in there because some people did sign up for special credit monitoring or credit protection with Equifax, but a very small part of the class. But at base, it's a negligence claim. They had a duty. They had a duty, we claimed, to protect the data of everybody, that it was, all the data it was holding for all these customers, and they're not really the customers; they're unwilling customers. And the Judge Thrash, in the motion to dismiss on the negligence claim, believed there was a duty, and that was really the core of the case.
So is that case still pending, Andrew, or did that case ultimately resolve as well?
It is still pending.
Okay. Well, okay, so that brings us to what I think is sort of the Mac Daddy of the data breach cases, which is this Marriott case. And depending on who you talk to, I know the figures are somewhere between close to 400 million and 500 million people, which is pretty remarkable. Who were guests at a Starwood or Marriott Hotel. Were victims of having their personal data breached. Tell us about that. And you were recently appointed to be one of the lead attorneys in sort of steering that class action through the court in Maryland, through the federal court in Maryland. So what is, other than the scope and size of this data breach, what else is remarkable about this particular case?
Well, yeah, it's hard to avoid the scope and size.
Yeah.
It's just humongous. There's no other way to describe it. It's what they've talked about. They've acknowledged it's 383 million separate customer records. What makes this a little different, perhaps, is there's a subset there of people. Look, it's sort of the standard personally identifiable information that was taken. More than standard. There's Marriott says it collects something like 25 data points on everybody that signs up for Starwood or stays at the hotels. Things like your name and address, your date of birth, your preferences. I mean, there's a lot of things there. But what's really interesting is there's a set of people they acknowledge had their passport information taken. So this could be one of the first cases where that has raised its head. So, I mean, the U.S. government says that should be the most sacred thing you own in terms of identity, and yet they had more than 5 million unencrypted passports in their system that were taken, and another 18 and a half million encrypted passports. Think of the concept there. We're not sure why they were unencrypted. We haven't gotten into discovery yet, so we just don't know. But what are they doing with that? Why is that unencrypted? But that's sort of a different angle than most. It costs you, I think, $100 to replace your passport. And if I went on the Marriott website now and plugged in my name and it said, "Oh, they took your passport information," I would want to go out and get a new passport. I don't care what it costs, but that is, I mean, ask the government. The government's going to say these are to be protected, with your life. This is sort of the most crucial information.
Yeah, I would want to know too.
On national security.
Well, yeah, I mean, I would want to know too. Is that something that is? I mean, at the end of a case, you told us there are, as part of a settlement, it can be that that the company has to provide some type of credit monitoring in the future. But what about this? I mean, probably if you've had your passport compromised, you don't want to wait years till a litigation concludes to have some resolution of that. Does Marriott have to disclose this to all the people involved so that they can take action while the litigation is working its way through the court?
Well, Marriott has put up on a website an ability for people to do that, at least find out what information was taken from them. And so I would encourage people to go there and make that inquiry. I think you put in your information, and then they will tell you what was taken. And if your passport was in there, if your passport was taken, I can't advise you. I'm not the lawyer yet. I don't actually represent a class. But if it were my one-on-one client and their passport information was taken, I'd say I'd go get a new passport. I don't think you want that information out there. And in fact, Marriott made sort of a half-hearted offer. When some of the pundits demanded, well, shouldn't you replace all the passports? They said, sure, we'll replace the passports. And then what they really said was, we'll replace the passports only if you can show that you've already had some kind of identity theft from the passport. So they're sort of making it, the most specific of injuries. Like you have to show that actually has already happened, rather than you're at risk for that happening in the future. So, I think it's really a game changer. You just don't see this in other cases.
Well, let me clarify something you said just a moment ago about there being a class here, because I know you've been appointed co-lead class counsel in the case, and I think you said there isn't a class yet, and I just want to make sure that we explain what that means. Is that because technically the court has to approve the class as a class, and we're just early enough in the case that we haven't crossed that point yet?
Exactly,
okay.
And I don't mean to play semantics here, but it's important. It's an important fact. When we're appointed to these cases, and when we bring the cases, we bring them on behalf of a putative class. It's a class we believe exists because there are consistent harms that befell each one of them, and those harms and the facts underlying them are common to everybody in the class. Here, 383 million people worth. But until a class is certified by a judge, which usually comes much farther down the road, it's not technically a class yet. It is a putative class. So I didn't mean to play semantics. I just want to make sure we're clear.
Well, no, but it is an important, although technical point, because a class action is a vehicle for a lot of people who've suffered a similar harm to have those claims resolved without having to have all of these, literally millions and millions of people file individual claims, which would just be an impossible way for the individuals and for our court system to handle that. But here we have a class, but it does have to, as you explained, it has to go through a process where you demonstrate to the court that it meets the definitions of what a class is under the law, and then the court has to approve that. And so it's not. I mean, I don't think of it as semantics. It's just it is the way class actions work, and I
right.
assume,
and just to put that in context, in almost every case, defendants contest that this is a class. This is a certifiable class because it's in their interest to do that. They say, oh, no, there's so many unique issues, makes them not common because obviously if you can't get a class certified, these cases really can't be litigated or litigated effectively. So it's not just saying the judge puts a stamp on and says it's certified. No, this is a fight because defendants always put up a fight on this, simply because it's in their interest to do so.
Because effectively that would end the litigation if they were successful in showing that. No,
that's correct.
Right.
If you have 20 named plaintiffs, you'd be left with 20 named plaintiff claims rather than 300 million, claims.
Right. Now, there's another thing there's another factor in this Marriott case that I think is important. And it kind of gets to the question I want to ask you about that perhaps we'll wrap up our conversation. And that is the fact that, at least as you've alleged, Marriott, it took years. It took several years for Marriott to even appreciate that this data breach had happened. Tell us about that and why that's important to the case.
Yes, to us, again, we haven't rolled up our sleeves in discovery yet, but boy, that sure is a warning bell. They acknowledged that in July of 2014 is when Starwood, which was the predecessor to the merger, that's when they were first hacked. They didn't actually discover that until 2018. So that's sort of an unprecedented 4 years that these criminals had access to all this information. Again, we don't know the details, but that's what they've acknowledged. I mean, that is unprecedented. Usually, sometimes in cases it could be they find out about it or they find out about a breach and then they'll disclose it at some point. But the worst I've seen is it goes back maybe a year. This is 4 years. That is just warning bells go off on that. That's to us that at least ostensibly looks like real negligence.
Well,
somebody had to have caught that.
And it's a long period of time during which the risk of harm because of the data breach can be realized, that people are unaware that their data was compromised, and that gives the bad guys here a lot more time to take advantage of access to that private data.
They could have gotten a running head start on that, is another way to say it. They exfiltrated a lot of this data 4 years ago. They could have already been off selling it, on the dark web. It's an amazing amount of time. I've just never seen anything like that. So you're correct. That is a really fascinating part of this. And when we roll up our sleeves and get to really take discovery, there's going to be a story there. I don't know exactly how it'll play out, but there will be a story.
Well, let me ask you two sort of final questions, about what are some of the lessons learned here. And I know the Marriott case is early on. The Equifax case that you're involved in is still pending. But once you become aware that this is a real risk to any company that has access to consumers' private data, and we've heard stories in the news about hospitals whose patient records have been compromised. Banks have had customers' data compromised. Of course, the companies we've already mentioned. Once you're aware that a problem like this exists or has the potential to exist, what are the lessons for companies that have access to this data? And then secondly, I want to ask you, what are the lessons for us consumers whose data has the potential to be compromised?
I think the lessons for the companies worldwide, if they haven't gotten the message yet, is they have to be incredibly vigilant, and they simply haven't been. They have not been vigilant on their cybersecurity. Some actually have, in some cases you see they actually have decent internal guidelines, but they sort of give it short shrift. They don't really pay attention to their own guidelines because they want to sell widgets. They want to sell their services. So that's not what they say, hey, that's for somebody else. Those days are over. You can't do that now. I mean, everybody knows the risk out there. Every company knows the risk. You have to be vigilant. It means you have to put a lot of money into it, but it's not just a one-time shot. It's got to be, continual, by the minute, real-time monitoring. That's one of the big lessons that you learn from a lot of these cases.
Well, and I say,
consumer,
well, hang on, before you get to that, I just want to add, I mean, I say this all the time in a lot of the cases I'm involved in where, company will have a policy, beautifully written policy and a beautiful manual of policies sitting on a shelf. I mean, it's not enough, obviously, to have a great policy or protocol. I mean, you have to actually vigilantly implement and enforce that policy. And these guys, may not be, the kid in the parent's basement on a computer hacking away at things for the fun of it. These are people who are out to wreak havoc, and obviously these companies have to do more to protect this data.
Yeah, no, you're absolutely right. This is it's not accidental that these companies get hacked. They're being hacked intentionally because they hold, a mother lode of information that can net them, millions or, collectively billions of dollars in information. So and you're also correct. Look, you litigate these cases too, so a guideline doesn't mean anything if it's not implemented. A guideline has to be followed to the letter, and so in the rare case, you actually will see some internal guidelines, and they're not bad, but they're only as good as the people overseeing them, the people that are, constantly monitoring what's going on. And in other cases, they don't really have the guidelines. They have very antiquated cybersecurity measures that probably weren't even effective 10 years ago, but certainly in this day and age are completely antiquated. In terms of the consumer, I can't say this enough, but you just have to be careful who you give your data to. And I even tell my kids, like, why are you signing up on that site? You don't know who has that site and what kind of cybersecurity. So I'm sort of I'm a Luddite when it comes to computers. I don't sign up for much at all. That doesn't mean I'm not at risk, because there are things like the credit bureaus that I can't control, but I'm not even on Facebook. I just don't want to do it, and I'm loath to really give my data out. I do on occasion, and it makes me nervous. And hey, it could be the small company that gets hacked that I give my information to, because I want some kind of ability to conduct my business quicker, like a bank or a salad place, right? But in the end, the more you give it out, the more you risk it. And let me leave you with one thought, which is, some of the companies get in there and say, well, how can you show it was your damage because of our hack if you may have been hacked from a prior big hack, right? Maybe you gave your information got taken in the Equifax data breach. So how can you be impacted now?
That's a great question.
The experts say is, I'm asking my own question.
Yeah.
Perfect.
Yeah.
Typical for me. So what the experts say is, it's not like there's one repository of information. Once it's there, it can never expand. The more that information is out there, even if it's repetitive, the increased risk dramatically. That you're going to get it, because most of the information is not in one place. It's sold in buckets. It's sold around, and people are aggregating it. So the more times you get hacked, the more risk you're at, dramatically so. So that's why, look, I can't shut down the cyber community. It's not my goal. It's part of our economy, but boy, I'd be real careful about who I give my data to.
Andrew, where can people go for more information on this? Do you have information on your firm website if people have just want information, or if they want to get sign up for the Marriott case or something like that? Where would people go for that?
Yeah, there's nothing they need to sign up for the Marriott case, but we do have information about our data breach cases. It's www.Cohen Milstein, CohenMilstein.com, and that's our firm website.
Okay, super. Well, thank you so much, Andrew Friedman, one of the co-lead counsels in the huge Marriott data breach class action, and also in the Equifax case, partner in the law firm Cohen Milstein in their Washington, D.C. office. Andrew, thank you very, very much for helping us understand this so much better, and for being on Good Law, Bad Law.
Hey, thank you. Have a good day. Appreciate the time, Aaron.
Thank you, Andrew. Take care.